Imagine this. You're finally getting your life back on track after a crash. You've been to the doctor, missed work, and dealt with pain you never expected. You file your injury claim, hoping for a fair shake, just some help getting things back to normal. But just when you think relief is on the way, the insurance adjuster slides a letter across the table. Inside, a list of reasons why your injuries aren't that bad and why your claim isn't worth much at all. Sound familiar? You're not alone. Every day I meet good, hardworking folks who suddenly find themselves fighting uphill against a company armed with excuses. The truth is, insurance companies have a playbook, and if you don't know their rules, you're at a big disadvantage. Hi, I'm attorney Jim Curtis. Today I'm telling the real story behind 5 favorite arguments insurers use to shrink your compensation. We'll unpack why these reasons miss the mark and how you can turn the tables to make sure your injuries and your recovery are taken seriously. So let's dive in. Argument number 1, your injuries are pre-existing and not caused by the accident. This is a classic. The insurance company will dig into your medical records to find anything, an old back strain, old car crash, even that gym injury months ago. They'll argue you weren't hurt here, you've always had this issue. But here's the truth. An accident can make a pre-existing condition worse or aggravate an old injury. Under Florida law, if an accident worsened your prior condition, the negligent party is responsible for the increased harm. Don't let them get away with blaming your injuries on the past. Counter this by getting your medical provider to clearly explain how your condition was made worse and show medical records that document the difference. Argument number 2, you didn't seek medical treatment right away. Insurance companies love this one. They say, if you were really injured, wouldn't you have rushed to a doctor? In reality, many people experience shock or adrenaline after a crash, masking pain. Sometimes the aches don't show up for hours, days, even weeks. You counter this argument by explaining the real reasons for any delay. Maybe you thought your pain would just go away, or maybe work or family responsibilities got in the way, or you weren't sure how serious your injury actually was. The key is honest documentation and following up with care as soon as symptoms appear. Medical experts can connect delayed symptoms to the initial accident, making this argument much weaker. Argument number 3, you overtreated, or the flip side, you didn't have much treatment. This is a sneaky insurance trick. If you attended lots of therapy or doctor visits, they'll claim you overtreated or ran up unnecessary bills. If you had only a few visits and tried to limit your medical bills, they'll argue you weren't really hurt, but treatment should match your symptoms. If your doctor recommended physical therapy twice a week, follow it. If you didn't need lengthy care, that's a sign of a less serious injury, but it doesn't mean you weren't hurt. Counter overtreatment by making sure every visit is medically necessary and supported by your provider's notes. Counter not enough treatment by emphasizing that your recovery was genuine and your providers cleared you when appropriate. Remember, the right amount of treatment is determined by medical professionals, not insurance adjusters. Argument number 4, there are gaps in your treatment. The insurance company will look for any break in your medical care and say, you couldn't have been in pain if you didn't see a doctor for a few weeks or even a month. But life happens. Appointments get rescheduled, personal problems arise, or you think you're getting better only for pain to return. Don't let gaps ruin your claim. Explain any gap with honesty. Did you lose your insurance? Did a provider schedule delay care? Document your reasons. Medical providers can explain in the records why a gap happened and the connection between your accident and the continued pain. And finally, argument number 5, you couldn't have been hurt. Your car had little or no damage. This one gets under everyone's skin. If your vehicle isn't mangled, you can't be hurt. But studies in real-world cases prove you don't need a twisted bumper to suffer serious injuries. Modern cars are built to resist damage, but the force still transfers to the occupants. Think whiplash or soft tissue injuries. Counter this with evidence from biomechanics experts, crash test studies, and witness testimony. Remind the insurer that your pain isn't measured by your bumper. It's measured by your medical evaluations. In closing, remember, insurance companies are trained to minimize your injuries and your claim. These 5 arguments show up again and again, but if you're prepared with facts, honesty, and strong medical documentation, their excuses won't hold water. Now that you know some of the most common arguments that insurance companies will use to try to get a discount on your claim, be sure to check out this next video to learn some simple steps you can take to maximize your personal injury settlement. See you there.